Welcome to today's episode of Momentum Monday, Supercharged with Emily, the podcast. And today is the day for legal questions. If you want to know how to start up your startup the right way from the start, then you're in the right place with our special guest. Stay tuned for more legal advice and tips. Okay, so happy to have you today on Momentum Monday. This is a very important episode for all of our business owners or aspiring entrepreneurs or anyone interested in starting a business, or if you are already in business and we want to make sure that you're covering your legal bases, then our guest will have some wonderful insights for you to really help you to supercharge your business from a legal perspective. So without any further ado, I want to welcome the one and only Nico Apfelbaum, an award-winning rising star, top of his game attorney here in Florida, who has great wisdom to share with you. So join me in welcoming Nico. Welcome, Nico. Great to see you and have you on with us today.
Hi, Emily. Thanks for having me.
Excellent. When anyone has seen like the Instagram stories I've been posting, Nico has some really vibrant posts on his Instagram page. It tells where he's from, and it started off by saying that you're from Argentina. Entonces hablas español y todo esto, ¿verdad? Claro que sí. And so you have a lovely background and in history. So tell us how you became an attorney. What even brought you to the field of law in the first place? A little of your background.
Yeah, so I was a finance major at the University of Florida. At some point, I decided that I didn't want to pursue a career in finance, and then decided to go into law school, but maintain my background on business, my background on finance. So a lot of my practice surrounds the business transactions, business litigation, commercial transactions, real estate, and so forth. So I stay in the same areas, but in the legal side.
Okay, so mainly, so still being able to understand the business side, obviously you're able to address the legal issues very well because you understand how they both work together, which is really critical.
Mm-hmm.
So guys, I have to say that I don't know if I mentioned before how excited I am to have Nico with me today. I've known him for many years, and I'm so happy to be able to showcase and share with you all someone who is an expert in this field. And as we launch this Ask the Expert series, which I have going on for November, Nico will highlight various legal things. So we're going to just kind of jump right in to, I think, the most burning question a lot of entrepreneurs have. What should I do, to LLC or not to LLC? That is a question. How do I choose my corporate entity and what's the difference between them? So I know that's two questions in one. So I'll let you break it down as you best can, Nico.
Sure. That's definitely one of the key questions that we have a lot of our clients or potential clients that they come ask us.
Yeah.
Whenever you are running a business or starting a business, definitely incorporate that business into an entity. Don't run your business as a sole proprietor. You should have an entity that conducts the business. When I mean entity, that can be an LLC, that can be a partnership, that can be a corporation. Which one you select may vary depending on several factors, such as tax consequences, such as the type of line of business you are. But the majority of our clients end up being LLCs. LLCs are flexible entities. They have the protections of corporations and partnerships, the flexibility of partnerships, but they are not as rigid and not as rigid as corporations. So LLCs are generally the top choice, I would say, in choosing the right entity.
So With that being said, Nico, how would you choose? Okay, so for example, a lot of business owners starting off by themselves as a sole proprietor type status, and now they want to incorporate into an entity of an LLC, like you said. And for those who don't know, LLC, limited liability corporation, right? And you have kind of two versions of it, and you can maybe clarify this for us, whether you are a single member LLC or a partnership. What are the distinctions between those two?
Well, the distinction between a single member LLC or a multi member LLC basically varies on how many members, how many people own um, an interest in the company. Same as you will have shareholders, same as you will have partners in an LLC, in a limited liability company, they are called members. So you want to specify, not necessarily with the Department of State when you register your company, but when you are having a multi-member LLC, which means two or more, it is always important to have what is called an operating agreement. An operating agreement delineates who owns the company, delineates who are the managers of the company, or whether the company is managed by managers or by the members, and also delineates other things like distributions, contributions, the obligations and responsibilities of each member, and many other things. But it is important to be clear when you have, more in particular, when you have a multi-member LLC, it is important to have in writing what each party does, what each owner does, what each owner contributes, and what each owner's responsibilities are. Because as part of our practice, we not only do transactional work, but we do litigation side, and a lot of the issues that arise all the time are partnership disputes. When I say partnership disputes, could be shareholders, could be LLCs, could be partnerships, and basically means we enter into this agreement whether with a handshake, whether with a unfortunately improper or not complete agreement, and here we are, months, years later, in a dispute, trying to separate each other or trying to determine, what rights each person has, how much money each person is entitled, and so forth. So it's always important to put things in writing. That actually will be my answer for a lot of things. Put things in writing.
That is the ultimate legal advice of all times, right? Put it in writing. Put it in writing. And I think a lot of people, what they tend to overlook and realize that we're human beings, and human nature kicks in on a very regular basis. And although today we're all smiling and everything's great, once something goes wrong, things can quickly fall apart. So you need that objective document to kind of be the
Correct.
arbiter, if you will, right? So can you give us some examples of some of the partnership disputes you deal with? What are some of the most common things, and how can they be avoided?
Uh, Most common ones, I will say, the type of contributions each partner had to make, whether that would be monetary contributions or um, labor contributions or some other contribution. Other partner disputes may be uh, what each partner has to do. There are disagreements between partners. One has an idea of which way the business should go. Another has another idea of which way the business should go, and they cannot run together. They cannot do business together anymore. So they're looking to separate. And whether it's through litigation or whether it's just through negotiating and putting things in writing, we help them separate and go their separate ways in terms of whether you dissolve the company or whether one of the partners buys the other one out.
So how do these disputes usually end up? Like, how do they get resolved?
Well, it will end up one of two ways. Um, I guess you can end up with third way where they reconcile and continue business, but I rarely see that.
Mm.
The 90% of the time, from my experience, it ends up with one party buying the other one. Um, so one of the partners leaves, sells their interest to the other partner, to the company. So now we have, you know, is not part, not that the partner that leaves is no longer a part of this business. The other way, if there is no way to reach an agreement, you can always ask the court to dissolve the company, and it's basically like a divorce. Everything gets sold, and you have to pay liabilities, pay the expenses, and then if there is anything left, it gets distributed to the owners. But generally, when you're pushing one of the parties to dissolve the company, you may have one party more interested to buy another one out to continue the business.
Hmm. Okay, so that's interesting that you say that 90% of the time they will one will buy the other out. So that means that you don't have to go to court
Mhm.
over that, or is that something you can just deal with between the two
Oh,
parties without court?
yeah, you can do it between the two parties or the parties involved. Yeah, and there's no need for court. I mean, you can obviously do it during court, but there's no need to do that during court with court involved. You can always do it negotiating whether there's another attorney involved or whether um, directly with the other partner that is trying to leave or stay.
So okay, excellent.
Mhm.
So, what would you say, Nico, are some of the steps that people need to take? So that you have this idea for a business, or you've already just started one. From a legal perspective, what are the next best steps for legal best practices?
Sure. So the first step will be what we are discussing is create an entity. You're about to start a business or continue doing business. Create an entity, generally an LLC, but maybe a corporation. But don't do it as a sole proprietor. You want to create an entity. You want to protect yourself from personal liability as much as you can. Register. You have to register with the Department of State to create your entity. You may need to have county, city, or state licenses depending on your business. Then when you're doing a business, you may have copyright matters, you may have patents, you may have any other type of intellectual property. So if you have any of those things, consult an attorney that does those things so you can protect your intellectual property. You can get a patent, you can get copyright, you can get trademarks on you know, on your business, on what makes your business what it is. Then, if you have a multi-member LLC or sometimes a single-member LLC or entity, have an operating agreement. Have an agreement that dictates, like I mentioned before, what the rights, responsibilities, contributions, and so forth of each member, each owner is. As you move forward, then, what are you doing? Are you selling products? Are you selling services? So you have to look. Do you need a service agreement with terms and conditions? Do you need an independent contractor agreement? Do you need employment agreements? Do you need liability releases? So you have to look at what kind of business you're doing and the type of agreements you should have in place to protect yourself, to protect your business. If you're having employees or contractors, I was mentioning independent contractor agreements or employment agreements. Are you training those employees? Are you allowing them to access your confidential information? So you may want to have confidentiality agreements. You may want to have non-compete agreements, non-solicitation agreements. Um, Other ideas or other things I tell my clients is have a team of professionals. You need an attorney, you need a CPA, you know, who will give you tax advice, will tell you how to best structure things, how to best do things that will be advantageous for tax purposes. On the legal side, you know, I've been mentioning all these agreements that you should have in place. But not only we can draft agreements, an attorney can also review your agreements. So are you entering into a lease for commercial property? Well, we reviewed those leases. Do you have a non-compete with your prior employer? We can advise you in terms of, what that non-compete prohibits you from doing, what the confidentiality agreement prohibits you from doing. Are you buying a franchise? Well, we review and we work negotiating on franchise agreement. So it is always advisable to be proactive. and not reactive. But what I mean by that, it's what you're asking me, Emily, is what are the legal steps that you can take? And I'm mentioning all these legal steps that you can take to prepare yourself from anything that can happen. Many times we get clients that come to us after the issue happened when we could have tried to prevent it by creating any of these agreements. So when they come with the issue already, let's say a contractor leaves and starts taking clients. Well, they did not have a non-compete agreement, so your options are more limited now. Well, it's going to be more costly if you come to us with an issue rather than trying to be proactive in having us trying to draft these agreements for you.
Wow, Nico. Oops. I don't know where to start with the questions. There are quite a few, and I actually have one on Facebook that I'm going to share with you in a moment.
All
But I
right.
think the key here is the proactive versus reactive. So it begs the question about the cost. So with all these agreements and all these potential, not everyone needs every one of these things. Like you said, it depends on their business, what's
Hmm.
necessary for them, and what stage they are in things. So everything has to be relative within the context of each individual.
Correct.
However, when you're starting, what would be, again, I'm going to focus on the single member person, kind of the sole individual, even though they're doing the single member LLC. What kind of budget might they want to have in place to cover themselves legally starting?
That's a broad question, and I think it depends. We have they're different attorneys with different levels of experience, um, and like, on the same side, they're different clients that need different things. A client may come that only needs us to create the entity and create an operating agreement, and that should be pretty straightforward and simple. However, we have other clients who already come with the idea of we're going to be doing cleaning services and we need a service agreement and we need liability releases and we're going to have employees. Well, your budget is already bigger because you need all these things and you come with the plan already set up. Um, so it is a tough question. Um, and something else that I wanted to add, I thought about adding to the prior conversation is, or question, is a lot of times we get clients who come with the pre-film, pre-filled forms that you can buy online or you can get online. And while for some people that may be sufficient, that's not always the right answer, or it's not always correct. And actually, one of the main issues that we have encountered is people say, me and my partner or me through my business are doing X, Y, and Z. Look at this is the form that we use, and unfortunately, it doesn't say, may not say what they think it says. So we had to correct that, correct those issues as well. And unfortunately, they have already spent money on those things, um, and here we had to potentially start from zero on creating those agreements again.
Well, I think what people are trying to do sometimes, well, we all want to save money, I guess, and people tend to cut
Oh, I
corners.
agree.
Unfortunately, they may not know where to cut the corner, and they may cut the wrong corner. But when it comes to legal things, you don't want to be cutting corners.
And sometimes it may work for you, sometimes it may not work for you. And I understand each business has their own budget, each business has their own uh, needs. So I think it's important to always have a consultation with an attorney who will help you assess what your needs are, what the urgency for each of those needs may be, and that attorney will be able to give you a budget on what you need. Yeah, on what your specific needs may be.
I think that's excellent. That's excellent. So you start with that initial consultation to go from there to create like your own individual roadmap. I think that's
Right.
a great launch point for
Hmm.
most for businesses to consider. Okay, so here is a question from Facebook, which is from overseas, by the way. It's
All right.
actually from Scotland. It says, "How can I restrict my liability when selling e-bikes from the USA to Scotland. He says other than the limited route. So I know that in the UK it's a limited. They're called something else other than, well, similar. Maybe you're more familiar with the terminology, but limited something, but, or maybe it's just
Okay.
limited. I don't know. But anyway, he wants to know how can he restrict his liability when selling overseas from the USA to Scotland. Okay, but he's
To
in
Scotland.
Scotland.
All right. So first caveat: I'm a Florida licensed attorney. I can only provide legal advice to regarding to Florida law. That's, I guess, my first caveat. Second caveat is, as an attorney, I have ethical restrictions where I cannot provide specific legal advice without someone being my client. That said, you have to look at the there are liability waivers you can put. The liability waivers you can put in Florida to try to prevent liability from um, damaging your business. From someone coming and damaging your business. Does that stop people from suing them? No. No, the people may still sue you even if they sign a liability waiver. May still sue you even if you have all these waivers in your contracts. What you are doing by creating these liability waivers, by having these releases, waivers, and whatnot in your contracts or your terms and conditions and what or set for or so forth, is trying to limit your liability, whether they sue you or not. So here in the United States, in Florida in more particular, you will have language in your terms and conditions. You will have language in documents that you make your consumers or um, whoever is receiving your products or services. You're making them sign these releases. You're making them sign your waivers to try to prevent that liability. And you see those releases, you see those waivers everywhere. You go park your car in a parking garage, look at the back of the ticket. They are there. Um, so those releases are everywhere.
And so some of those laws are similar overseas, even though your jurisdiction is Florida. Um,
Hmm.
the suggestion would be too to see a local attorney to where you're located for more precise coverage of
Correct.
where you're located. Yeah.
Correct. If you're providing services, even here in Alabama or New York, you will
Hmm.
need an attorney in Alabama or New York to set you up and get you the protections that will apply in those states. Similarly, if you're selling your products in Scotland, you will want someone in Scotland who will know the law in Scotland and how, they may not be as litigious as the United States is, but you will want to know what needs to be done to prevent or limit the liability you may have.
Okay. Now, do you work with lawyers overseas also to have kind of like that liaison between international lawyers when you're maybe doing something that has an international dimension?
I have worked, yes, in a few cases. I have worked in different type of matters with attorneys in let's see, Italy, Switzerland. I think there was Germany as well. So I've had a few cases where there have been attorneys um, in different countries, and we work together.
Right. So,
Hmm.
Nico, could you share with us what are some of the practice areas your law firm covers and your specialties with at Apfelbaum Law?
Thank you. So right now at our firm, we're three attorneys. We practice myself. I do commercial transactions, commercial litigation, real estate transactions, real estate closings, real estate litigation, probate matters. Then we have attorneys who do criminal matters in our office, who do family matters in our office, and as well as guardianships.
Okay, well, what was the last part that you mentioned? I think that I didn't hear that quite clearly. What was the last thing that they do?
They do criminal, family, and guardianships as well.
Oh, guardianships. Okay.
Guardianships, yes.
Okay, I got you. Okay, very
Mhm.
good. So, for general business matters like we're discussing today, well, you do commercial litigation, so business law is a key part of what you're doing as well. I
Correct.
mean, as an umbrella, if you will, umbrella kind of category
Hmm.
to reach out to. Because we always recommend, when I deal with my clients, I always recommend a good attorney and a good CPA when they're starting off, or at any stage really, but especially when they're starting off. Just like what you were saying before, having that consultation to know what makes sense for them instead of just
Correct.
following what they've heard or think they should do, and then it might not be their particular situation.
Hmm.
So it's just as a good best practice, and that's what we're talking about today: setting up your best practices for your startup from a legal perspective. So, Nico, are there other things that business owners, maybe pitfalls that sometimes they're not aware of that they could prevent? And I know obviously you shared quite a few today about the different agreements and so forth, but what are some, maybe something that's so recurring or happens all the time that please prevent this one thing if you do nothing else?
I think one of the main issues we see actually is employers having contractors, employers having employees, and they share their customer list, they share their confidential information, they share um, their trade secrets, and then their contractor, their employee leaves, and they start a competing business. Well, with some limited exceptions, there may not be much you can do from this employer contractor from starting their own business unless you have a non-compete agreement. A non-compete agreement are, as long as it falls within certain parameters in Florida, they are valid, and you can restrict competition if you have good grounds, legal grounds. So one of the pitfalls we see is, you know, having contractors, having employees without a non-compete, um, and then letting them go and compete against them.
So how do you enforce a non-compete? Like how is that enforced?
For the most part, generally, we start with the demand letter. Um, the circumstances change, but for the most part, we start with the demand letter, and then if that doesn't work, then you have to avail yourself with the court, go to court and try to get injunctions and damages. Well, injunction will be the prohibiting someone from competing. So that
Hmm.
will be a order saying stop competing. And then um, damages will be an argument saying, former employee left, I lost X amount of business.
Hmm.
This is much how much money I lost, or what. There are different theories, but this is how much I was damaged, and the judge may award damages in your favor and against the former employee. So unfortunately, you had to go through the courts to get a non-compete enforced. Um, so, but a demand letter a few times may work.
So what if the person moves to another state? Is it harder to enforce, or is it just within the state or a certain geographical zone when non-competes are in place?
Sure. So a non-compete has to be, among other things, reasonable in time.
Hmm.
So there's some guidelines under in the law that says 2 years may be reasonable. If it's a former owner, I think 3 or 4 years may be reasonable. So reasonable in time, reasonable in geographic location. So if you have a business that only does business here in, let's say, in the Treasure Coast, you may not be able to say don't compete against me throughout Florida. Don't compete against me throughout the United States, because you don't do business in you don't do business outside the Treasure Coast. So you want to uh, make it reasonable geographically as well. Otherwise, it may not be enforced, or it may be limited by the court. But we have had other cases, especially with online presences, online businesses, where a non-compete throughout the United States may be enforceable. But like you mentioned that what if it's in another state? Yeah, it may vary state by state. We try to make it enforceable under Florida law, and other courts may have to follow Florida law if that's the law under the non-compete agreement. But different states have different but similar laws, I would say. And you had to go to those states. You had to go to those states to try to enforce it for the most part.
Okay, I have another burning question to ask you, but before I ask that, let me remind our viewers to please kindly subscribe, like, comment, share. If you're watching on YouTube, subscribe at Supercharged Coach and let us know any questions in the comments as well and what you benefited the most from today's conversation. So that would be wonderful if people do that. So thank you, everybody. So now, Nico, here's my burning question. So with
All
a
right.
non-compete, okay, 3 years, 2 years, what should that person do in the interim if they're not able to do the thing that's their specialty?
That's the burning question for many client people that call us as well. Unless you want to go to court and test that non-compete, you may be restricted from competing within the geographic location. So I have had clients who, in both sides, whether the employer or the former employee, and they may have to go to another, work in another city. Let's say, like I was saying, it's limited to Port St. Lucie, it's limited to the Treasure Coast. Well, maybe for a year or two, they may have to go work in West Palm, work somewhere else.
Yes.
Some people decide to change their not profession, but what the limited restriction on what you cannot do. They decide to do something different, maybe for that year or 2 years, or other people that have had situations that the employer may be willing to buy them out of the non-compete, or the employer may decide not to enforce it, not enforce the non-compete. But those are generally the options, because if you are competing within the terms of the agreement, then you may find yourself in court and potentially trying to determine whether the agreement is valid or not, whether you're in the employer or the employee side.
Okay.
Mm-hmm.
Oh, wow. So many things to consider. So many things to consider. So let me ask you one more thing regarding the online space, since you mentioned that for a moment. A lot of people are launching online businesses, memberships, selling digital products, all kinds of
Mm-hmm.
things of that sort. Are you working with those types of clients as well in terms of their agreements online that they should have in place for the digital space?
We have done a few, not many. We have done a few. Um, for the most part, whether it's online or whether it's a product, let's say, or membership, it all falls to the same thing. You want to have proper terms and conditions, obligations, responsibilities, and whatnot relating to what you're offering. There may be other disclosures or other accessibility issues that you may be faced with online presences, but for the most part, it's putting in writing clearly what what the responsibilities, obligations, and things and terms and conditions may be.
Okay, so that does not change. Everything needs to be in writing yet again. That's
Right.
the whole that's the whole point. That's the whole point.
Right.
So yeah. So it's thinking kind of from a legal perspective, which I think a lot of people, we kind of just want to get down to the business of business, but realizing that there's an infrastructure in which we need to operate in order for the business to work optimally. So
Right.
that's
There are people that operate for years without anything in writing, and they're fine. So you never know. Obviously, the advice is to have things in writing, to put all these agreements in place and whatnot. Some people do it, some people don't. Yeah.
okay. So what would be your, to summarize where we are today and like the major takeaways? I mean, everything is a major takeaway. I certainly encourage anyone who's watching this, watching it live or on the replay, or when you get to listen to this, that you probably will have to listen to it more than once. And definitely write notes. I was trying to take notes while you were talking. I can't keep up with you. So I'm like, that's what it will take to really kind of go back and make sure you understand what's
Hmm.
being highlighted. But to simplify it, the whole idea of being proactive versus reactive, I want to just reiterate that point that you so well made, and also just understanding your situation. So, what would be your summation of anything else that you think our small business owners or business owners should know or keep in mind going forward on the legal spectrum?
I will say one of the main things will be do not operate as a sole proprietor. You're exposing yourself for personal liability. So create an entity. Creating an entity is easy, it's simple, and not costly. Whether you get someone to help you or not, it's still pretty simple. Um, and follow with that is get everything in writing. Whether you do it with an attorney, not an attorney, whether it's an email, having in writing. Everything should be in writing at this point.
One more thing, and thank you very much for that. I just want to just one point just to cover in case someone who's listening to this, they might be interested in being a S corp or a C corporation.
Mhm.
What might their consideration between choosing that versus an LLC?
We work. That's more of when we work with their CPAs. They make their elections on terms of how they're going to be taxed. Are they going to be a C corp, an S corp? And I was mentioning earlier, one of the reasons we do LLCs is because of their flexibility that they have. And one of those flexibilities is for tax purposes. But again, we refer that we stay on the legal side, at least our office, we stay on the legal side. We refer those things to either a CPA or work with our client CPAs.
Okay, excellent. So the shows that your lawyer and CPA can work in tandem in optimally looking at both sides of what you're doing. So that's really
Correct.
how that works, and that's how it overlaps. So the overlap between the legal and the financial side. Okay,
Correct.
that's great. Well, I think that's extremely helpful, Nico, and all that you've shared today has been absolutely tremendous. And I know that everyone who's watching this will benefit tremendously from it. So, with that being said, let me make sure that I can't leave out our sound effects. Can't leave out our sound effects. But I just want people to stay tuned for a moment. I want to share with you what's coming up next. And since we had an amazing CPA lawyer, Esquire, Nico Apfelbaum with us today, next week we're going to have with us, just a second. There he is. All right. We're going to have Assad Ahmad, who is a CPA, a certified public accountant, who will be sharing with us if you're self employed, what are some of the accounting best practices, or small business owner, or whatever your status is. So bring your accounting questions next week for Momentum Monday because it's a great follow on to today's amazing topic so that you just don't miss out on all the interesting things to know for your business. The second thing is that we will be having our free challenge on November 28th and 29th, our Distraction Elimination for Entrepreneurs Challenge, people. Sharpening your focus and simplifying your priorities. So save the dates and stay tuned for the links for that to sign up because it's going to be really valuable for this time of the year to hone in on your goals and live a distraction free life. And then finally, I want to leave you with our positive energy supercharged thought of the day. And that is the world needs you. The world needs you more than you can ever imagine, that you can make someone's life better by what's been put on your heart to bring forth your mission, your vision of what you feel the world needs. So I want to encourage you that even though there are obstacles along the way, stay focused on your value and what you have to bring, and the world will be a better place because of you and your vision. So with that, I want to thank you for being here again. Yes, and let me thank Nico one more time. So wonderful to have you, and everybody stay supercharged, and we'll see you soon.